In the age of today's technology, why would a person not want to go get a trademark by themselves on the internet?
Well, that's something that a lot of people choose to do, and I guess nothing's stopping you. The problem is that there's a whole host of rules as to what is eligible to be trademarked and what isn't. In fact, there's books like this, giant books dedicated to that specific topic. A lot of rules, a lot of things to know on what you can and can't get a trademark on. So if you go out on your own and you file a registration, you're taking a risk that you might have violated one of those rules. What's the advantage of hiring an attorney who's licensed to practice before the Patent and Trademark Office and who does trademark applications for a living is I know those rules already. I mean, you can take the choice to either learn the rules yourself, or you can roll the dice and just say, I'm going to file this registration and hope that I don't violate one of the rules, or you can hire somebody that already knows. It's not well known, but somewhere on the order of 75 to 80% of trademark applications actually get initially rejected. The examining attorney who's assigned to the case finds a problem. Sometimes it's small trivial details that are easy to fix, but a lot of times it's problems with the mark that you've picked. It's something that's wrong. You can't have a mark, for example, on a descriptive word or phrase. You can't have a trademark on national slogans. The rules go on and on. So if you roll the dice and you file your application and don't know those rules, then you're likely to get one of those office actions that rejects your trademark application. If your application gets rejected, you lose your filing fee and you lose all the time you've spent. You're not going to find this out for 6 to 8 months after you've filed your registration that you're not going to be approved. So awful lot of time to lose, and somewhere between $275 and $375 in your filing fee is just flushed because you get rejected and all that effort's lost. The better approach, at least in my opinion, is to consult with somebody who already knows the rules, who can help you screen your mark before you even walk into the door, before you pay the filing fee. We can get you a mark, get you to select a mark that's going to be registered. We can guide you around the pitfalls of the application process and give you the highest likelihood of getting a registration. And I should point out on that topic that except in cases where I identified a problem with a trademark that a client wanted to register for and told them about the problem, and they decided, you know what, we're going to take the risk and we'd like you to file even though we know about this problem. Other than those circumstances, I've never gotten what's called a substantive office action. I've never gotten one of those rejections based upon ineligible trademarks. So it pays off having somebody who knows what they're doing help you to screen before you file and before you pay that registration filing fee.